and I'm here now to talk to you about a remedy that we've been practicing and I've been actually using for the past 5 years. Now, I'm only going to deal with evidential facts here, so it's all provable. All this is what we're saying is, don't just trust me and believe what I'm telling you, look for yourself. We've got a Facebook group page, Practical Lawful Dissent. If you go in there and have a look in the files, you'll see all the evidence, there's templates, there's all kinds of stuff that you need to know about entering into lawful rebellion and actually using the process to a successful end. Now, there's a lot of misconceptions about lawful rebellion, one being the barons. The Barons Committee, which was a quorum of 68 originally, broke up, set up 25 of their number to look at whether the invocation of Article 61 was going to be necessary. So, this was in 1999. They set the quorum up and they discovered that the Nice Treaty was a treasonous document, and that they had an obligation under the common law, under constitutional law, to petition the monarch not to give royal assent or to ratify the Treaty of Nice. Now, the barons have been vacant, they've been AWOL. Since they invoked Article 61 for the people to use, they've gone AWOL. So the oath of allegiance that we write up and send to one of these barons is basically to prove with the document of our intention. So we're standing under Article 61, Magna Carta 1215, pledging allegiance to the barons as long as they comply to constitutional law. And that's the big crux of it. They're in service to the people, it's not the other way around. They already served the people by invoking Article 61, which is evidential fact, as I said. You can check this out for yourself. On the group page we've got letters between the Barons Committee and Sir Robin Jamvrin, who was the Private Secretary of the Office of Sovereign at the time. We've also got Daily Telegraph reports of the invocation of Article 61 done by Caroline Davis from Daily Telegraph, written up on the 24th of March 2001, so you can Google that. You can see that it has actually been invoked, and it's not denied that it's been invoked. It can't be denied because it's all evidential fact. So we've entered into lawful rebellion by sending an oath of allegiance to one of the barons. There's a file in the group page of all their names and addresses, of current names and addresses of the barons. So we just do this to prove that we are not standing outside of the law. And in fact, we are the only group in this country who are standing under the law. Because if you read Article 61 of Magna Carta 1215, you will see that it's every sovereign man and woman's duty in the entire Commonwealth to support the barons in this process, or you're basically aiding and abetting a treasonous regime. So hopefully that'll quash a couple of the misconceptions about the barons and Magna Carta. It wasn't a contract that was signed under duress, as people are banding about. King John was a tyrant. He never had a sword at his throat to put his seal to the Magna Carta. He didn't actually want to do it. He walked away and later thought better of it because he was going to lose his place on the throne. So he was compelled, just like you might compel a murderer to take the stand in his defence, someone who's evidently committed murder. That's the same kind of duress King John would have been in at that time. The treaty was sealed at Runnymede on the 15th of June, 1215. This can't be denied. It's done. It's written on parchment, and you can actually read it yourself. It was done in Latin, but it's been translated. You can see that our rights, in fact our duty under the constitutional law, is to protect the Constitution. And once Article 61 has been invoked, then you have a duty. Everybody of this land has a duty to protect the laws that protect us. And that's another big misconception that people need to understand, is we're standing under the laws that protect us. If you read Magna Carta, you'll see that we have the rights to trials by jury, we have the right of habeas corpus, we have our inalienable rights codified into a treaty so that they can't be denied by any dictators that may come along in the future. And that's what these treaties are about. They're about codifying our natural inalienable rights that can't be given nor taken away. So they're not like, oh, I wasn't there, so I didn't sign the treaty, so it doesn't apply to me. Why wouldn't you want to protect your inalienable rights to justice? Because that's the trouble what we've got in this land today. And Sandy's shown you the points that prove that there's an imminent threat here. So why wouldn't we protect our system of justice that actually protects us from this criminality, these corporations that are trying to take over the planet? Well, we're doing it, and we're finding that we're having success with what we're doing because we're standing by our guns, and all we're doing is evidencing facts to those that are making demands on us. We're proving that Article 61 has been invoked, and therefore they have a duty to stand under it. Every individual does, and that we have a lawful excuse not to contract or to adhere to anyone making demands on us that are not standing under Article 61. That's the basic premise of what we're doing here. We send three notices. We start with a notice of conditional acceptance. So we will accept your summons or your fine or your demand for whatever it is on proof of claim that you have authority to issue that summons, demand or whatever since the Article 61 came into effect. What we're finding is that the courts are just ignoring us because they know very well, they're not courts of law, they're just private corporate entities deceiving everyone, because you have to consent to these hearings, otherwise they have no authority over you. We've got these private corporations tacitly agreeing to our documents by not responding to them. We send them recorded delivery, and once they're accepted by the Postal Service or someone signed for them, they've been accepted in law. So in our notices, we basically just ask that one question: have you the authority since Article 61 was brought into effect on the 23rd of March 2001? And like I said, so with the courts, they don't respond. And we carry on with the three processes of notices, which is the second one is the notice of default and opportunity to cure, to give them another chance to make good on the first notice, which they've acquiesced to. And the third notice is a notice of default, saying you're now in default, and you agree there's no claims against me, kind of goodbye. And you can see that process done against Yeovil County Court by Danielle De Lioness on the Facebook group page, and it's a very simple process, and they ran away. That was 3 months ago. She had 48 hours to present herself for a 7-day prison sentence after she just ignored the first two summonses, and this is over on water and sewage charges, which incidentally she's very much against paying because Margaret Thatcher stole the water companies in 1986. She privatised them, stealing a public service. We're using Article 61 to rebut the water. She's going after the council tax, and the sentence to 7 days imprisonment has now gone away. And we'll keep you all posted on that process. We've now served them all with the fourth notice, which I haven't mentioned yet, which is the notice of misprision of treason. Now, what we do with this notice is we evidence the treasonous matters by various individuals through the last 40 years, really, and we put them on notice of the facts, because under the 1795 Treason Act, Section 1, this is misprision of treason. Anyone that in the realm that knowing of an act of treason being planned or committed in the country has an obligation under the law to report that crime to either the police or a justice of the peace. And whoever does not do that, but in full knowledge of the facts, is committing a lesser crime of misprision of treason, which is total asset stripping if convicted of this, and life imprisonment.